After a lengthy delay, the State Bar of California is taking disciplinary action against Attorney John Eastman for his questionable efforts to overturn the results of the 2020 presidential election. This video discusses in detail the actions that the California State Bar is taking that very well may end in Eastman losing his license to practice law in the state of California. On January 26, 2023, the California State Bar issued a press release outlining the disciplinary actions that Eastman now faces. According to the press release, and I quote, "The State Bar of California's Chief Trial Counsel, George Cardona, announced today the filing of a Notice of Disciplinary Charges, NDC, against Attorney John Charles Eastman, State Bar number 193726. The 11 charges arise from allegations that Eastman engaged in a course of conduct to plan, promote, and assist then-President Trump in executing a strategy unsupported by facts or law to overturn the legitimate results of the 2020 presidential election by obstructing the count of electoral votes of certain states. Some of the charges allege that Eastman made false and misleading statements regarding the purported election fraud, including statements on January 6, 2021 at a rally in Washington, D.C. that contributed to provoking a crowd to assault and breach the Capitol to intimidate then Vice President Pence and prevent the electoral count from proceeding. The Office of Chief Trial Counsel is seeking Eastman's disbarment before the State Bar Court. The notice of disciplinary action sent to Eastman by the California State Bar is 35 pages long and cites 11 separate grounds for seeking his disbarment. I've provided a link to the document in the description for this video. In this video, I will describe briefly the 11 charges that Eastman is facing before the California State Bar Court. The first, and arguably the most serious charge against Eastman, is that he failed to support the Constitution and laws of the United States. California attorneys take an oath to support the Constitution and laws of the United States as well as the Constitution and laws of the state of California. This charge revolves around two memos that Eastman prepared for Trump and Pence that said basically that Pence had unilateral authority to overturn the election of Biden as president, even though this was clearly contrary to both the Constitution and U.S. statutes. Pence and Pence's legal counsel disagreed, and as we know, after a delay caused by the insurrection at the Capitol, Pence carried out his duty under the Constitution to supervise the counting of the electoral votes. Counts 2 and 3 relate to Eastman's efforts to support a move by the state of Texas to overturn the results of the 2020 presidential election in Georgia, Michigan, Wisconsin, and Pennsylvania, claiming voter fraud for which there was no substantial evidence. According to the Notice of Disciplinary Action, Eastman had been informed by Attorney General Barr and other government officials that there was no evidence of voter fraud in any state at a level that would lead to a different result in any of the 50 states, and that he knew or should have known that the claims made by the Texas Attorney General were unfounded. Count 4 of the Notice of Disciplinary Action is based on a similar action that Eastman took to question the validity of the election in the state of Georgia, again contrary to the fact that there was no evidence that sufficient voter fraud occurred in Georgia to affect the outcome of the election. Count 5 relates to a visit Eastman made to Steve Bannon's War Room radio program, in which Eastman again made claims of massive voter fraud in the 2020 presidential election that he knew or should have known were not substantiated by the facts. Count 6 relates to the 6-page memo Eastman wrote for Trump and Pence, in which Eastman made 4 claims relating to the 2020 election that he knew or should have known were false, including the claim that in 7 states, 2 sets of presidential electors had been sent to Congress. In the 7 states in question, the governor of each state had sent a letter of ascertainment indicating that only a single set of electors in fact were chosen, and they had voted for Biden even though groups of people purporting to be Trump electors had attempted to submit electoral votes. Count 7 relates to the speech that Eastman made beside Trump on January 6, 2021, in which he again made statements about voter fraud that he knew or should have known were false, and which encouraged people to march on the Capitol. Counts 8 through 11 cite additional instances in which Eastman claimed that Pence had unilateral authority to stop or delay the counting of electoral votes, or that extensive fraud had taken place in the 2020 presidential election, even though Eastman knew or should have known that his claims were not supported by the law or the facts. Count 8 relates to an email that Eastman sent to Pence's legal counsel on January 6, 2021, at approximately 2:25 p.m., while the Capitol was being stormed by a crowd of violent protesters that once again was intended to pressure Pence to adjourn the session in which electoral votes were being counted, and once again Pence's legal counsel rejected Eastman's arguments. Count 9 refers to an article that Eastman wrote for a publication of the Claremont Institute called The American Mind that was published on January 18, 2021, in which Eastman again repeated his claims of gross voter fraud in the 2020 presidential election, which he knew or should have known were not supported by the facts. Count 10 refers to the fact that between December 23, 2020 and January 6, 2021, Eastman repeatedly proposed and sought to encourage that Pence exercise unilateral authority to disregard the electoral votes of certain states or delay the counting of electoral votes using arguments that he knew or should have known were not supported by the Constitution, the law, and/or historical precedents. Finally, Count 11 referred to the speech Eastman made to Trump's crowd on January 6, 2021, and here I quote directly from the notice of disciplinary action. By telling the crowd of protesters from a position of authority as a professor and purported preeminent constitutional scholar that fraud had occurred in the election, that dead people had voted, that electronic voting machines had been used to fraudulently alter the election results, and that Pence had authority to delay the counting of votes, and that Pence did not deserve to be in office if he did not delay the counting of votes, respondent, that is Eastman, made false and misleading statements that contributed to provoking the crowd to assault and breach the Capitol in an effort to intimidate Pence and prevent the electoral count from proceeding, when such harm was foreseeable and thereby committed an act of moral turpitude, dishonesty, and corruption in willful violation of Business and Professions Code Section 6106. It should be clear from the brief descriptions of the counts in the Notice of Disciplinary Action from the California State Bar that I have provided in this video that Eastman's licensed practice law in California is in serious jeopardy. But if you need more convincing, I encourage you to read all 35 pages of the Notice of Disciplinary Action for yourself. Eastman is contesting the charges brought before the California State Bar Court. His attorney, Randall Miller, said that Dr. Eastman, a nationally recognized constitutional attorney and scholar, represented former President Trump in several election challenges. As was his duty as an attorney, Dr. Eastman zealously represented his client, comprehensively exploring legal and constitutional means to advance his client's interests. Well, we shall see whether the court buys that contention. I hope that you have found this video interesting and informative. If you have any questions, please leave them in the comments section and I will do my best to answer them. And if you haven't already subscribed to my channel, please do so.